Hello, my name is Matthew Alvarez for Business Law 421. My executive presentation is on racial discrimination under the Civil Rights Act. I'm going to start off giving you a little bit of background on the Civil Rights Act, tell you about compliance and how to be compliant. I'm also going to provide you with two case studies detailing some current events that are happening with racial discrimination. And I'm going to finish up with some recommendations for how to maintain compliance in our company. To start, I'll give you a little background. According to the Equal Employment Opportunity Commission's website, the Civil Rights Act of 1964 prohibits discrimination in a broad array of private conduct, including, but not limited to, public accommodations, governmental services, and education. Title VII narrows this down even further, saying that employment cannot be prohibited based on race, sex, color, religion, and national origin. The law was initially passed on June 19, 1964, with a vote of 73 to 27. It was passed only after the then longest debate in the 180-year history of the U.S. Senate. 2 weeks later, the bill was signed by President Lyndon B. Johnson, and so far, there have been over 500 amendments to the bill, and it has been debated for over 530 hours in the Senate. There are some similar statutes in the Civil Rights Act of 1964, and those include the Equal Pay Act, the Age Discrimination in Employment Act, and the Americans with Disabilities Act. States and cities often have their own anti-discrimination laws that reflect those on a federal level. The Equal Employment Opportunity Commission is the agency tasked with enforcing discrimination laws involving race. On the Federal Trade Commission's website, it states that Title VII protects employees for the totality of employment decisions. This includes recruitment, termination, and any other condition of employment. The EEOC deals with complaints made against employers. And to ensure an organization is being compliant, the prospective, current, or former employee must first contact an EEOC counselor within 45 days from when the event occurred. The counselor will take your information and attempt an informal resolution with the organization first. This is usually the timeliest outcome. If no informal resolution can be reached, the counselor will give you a notice of your right to file a complaint with the director of the EEO or possibly go through mediation. You have 15 days to file the actual complaint. If your case is accepted, the director will assign an investigator to your case and start collecting relevant information. The investigation should be completed within 180 calendar days from the date the complaint was filed. Upon completion of the investigation, the director will notify you of your right to either a hearing with an EEOC administration judge or a ruling from the FTC itself. The hearing is an opportunity for both sides to clarify their positions, to question witnesses, and to add to the record. The judge will either dismiss the case, decide on the merits of your case, or issue a summary judgment. After the ruling, a final order will be issued to the organization from the Federal Trade Commission. The first example I found was from 2015, and I found it in the Denver Post. 7 former employees filed suit against Matheson Trucking, also known as Matheson Flight Extenders, alleging racial discrimination. 6 of the defendants are black, and 1 was a white whistleblower that was fired for questioning the organization and its practices. The defendants were awarded $14 million in damages total. For each defendant, it was over $300,000 in back pay and $650,000 for emotional distress caused by the ordeal. At the warehouse where the defendants worked, blacks worked on one side of the warehouse and whites worked on the other. Often, white supervisors had less than desirable things to say about the black employees. In a few instances, supervisors were caught using racial slurs when referring to black employees. There was also an instance of a white employee yelling that all blacks should be shot. No discipline was ever brought to that employee, and that employee was actually later promoted. When layoffs came around, only black employees were let go regardless of seniority. The lawsuit alleges that the defendants were discriminated against in all phases of employment. The second example I found was from a website called HR Drive, and it was in our own home state of Michigan. It involved a married couple in the Michigan correctional system. The couple was awarded $11.4 million by a jury. The couple had claimed racial discrimination, a hostile work environment, and retaliation by the Michigan correctional system. Lisa Griffey was a probation officer working at the Michigan Department of Corrections. In the lawsuit, she claims that there was a culture of racism at the Department of Corrections, and she endured racial slurs and other racist messages. She filed a complaint with the department and transferred to another department where the racism continued. Her husband also worked for the Department of Corrections, but was forced to retire from his job. Disciplinary charges were brought against him shortly after his wife's initial complaint. The jury awarded Ms. Griffey $5.132 million and her husband $6.25 million. The state of Michigan is expected to appeal that decision. To ensure that our company is compliant with the racial discrimination laws of the Civil Rights Act, I recommend that we use the following practices. Overall, we should train all of our employees on the EEO laws and promote an inclusive culture, championing professionalism and respect for your peers. We should establish neutral and objective criteria to be used in all employment decisions. We should bring employees in with EEO principles in mind, try and increase the diversity of our pool of potential employees, and look at our current employment practices and determine if they treat any employees differently. Make sure promotion criteria are known and job openings are communicated to all employees. We need to make sure that compensation and reviews are made on performance and done with consistency. We need to protect against retaliation and give employees a clear path to notifying us of any transgressions. Lastly, we should take on a strong anti-harassment policy. We should train all employees on those policies and make sure it is enforced. We need to provide a clear explanation of improper conduct and ensure safety to those that bring forward complaints. We also need to make sure that we provide a transparent investigation and an immediate response. Even though this law was brought about in 1964, we are still trying to navigate it today. Organizations are still having to be forced into complying with these rules. The information brought to you in this presentation was collected from our textbook, the EEOC website, the Federal Trade Commission website, the Denver Post, and HR Drive. Thank you for listening, and make sure you're compliant with all of these rules.